Good morning. Thank you, everyone, for joining us here on Why to File a Tax Return for Lawyers for Learners. Please note that this presentation is being recorded. We are honored to have with us today two experts in their field. We have Andrew Belter, a staff attorney with Wisconsin Judicare, and Jay Miller, a volunteer tax attorney with Legal Action of Wisconsin. There's also some handouts for this presentation that Jay and Andrew made available to us, and they're in the lobby information desk in our platform. If you have any questions throughout this presentation, please feel free to type them in our chat box, and our staff will collect them, and then we'll answer all those questions at the end of the presentation. Again, thank you all for being here, and I'm going to pass it off to Andrew.
My name is Andrew Belter. I am the Low-Income Taxpayer Clinic Director at Wisconsin Judicare and an attorney. Today, our goals introduce what credits someone can claim even if they don't have a filing requirement. Important to know that you can still file, can still claim credits, get money in your pocket. Brief introduction about the requirements for those credits. We can't do a thorough explanation of all the ins and outs, but we'll give a brief overview, and then you'll be able to figure out if you can claim it, if you should investigate more. Then we'll transition to talk about our low-income taxpayer clinics, how we can help you. We're always here to try and help people. And then if you're in the unfortunate situation where you owe taxes, what possibilities there are to resolve that. Filing a tax return to claim credits. I do want to say this year, if you did not receive all of your stimulus payment, all that money, file your tax return because you claim your stimulus on it. Also, if you worked and had taxes withheld, file your tax return to get those withheld taxes back. But the credits you can claim, they're listed right here. We're going to go through each one and brief overview of everything. Hopefully you'll understand a little bit better what you qualify for and what you do not qualify for. The earned income credit, they expanded it this year, and it used to be 25 to 64-year-olds could claim it who had earned income. They lowered that age to 18 with a twist. It says 19 years old because that's the base cutoff for no children. Unfortunately, if you are more than a half-time student, you must be 24. That also is lowered, though. It used to be 25, now it's 24. And you know you're a half-time student. The IRS says if you attended school for 5 months out of the year, then you can't claim it. Unfortunate, but it's the rules that they go by. Also, if you are claimed by someone else, such as your parents, a lot of these credits are not available. Unfortunately, again, because your parents are getting credits for you. The twist is if you are 18 years old and formerly in foster care or experienced homelessness, you can claim the earned income credit as long as you have earned income, even if you're a full-time student. So how you do that is you have to check a box on your tax return, and pretty much if you're questioned on it, you just have to write a statement that you were in foster care from at one point from 14 to 17, or you're experiencing homelessness or at risk of experiencing homelessness. So you don't literally have to be homeless, you could be at risk. Another thing that they did this year is you can use your 2019 earned income. The IRS recognizes that a lot of people have struggled with work since the pandemic started. So 2019 earned income or 2021 earned income. Not sure if it's real relevant to everyone, but just to be thorough, if you get disability payments, that may qualify as earned income. And also remember, people over 64 can now claim their earned income credit with no children. The maximum amount, it's about 3 times what it used to be. Again, the government's giving an effort to get money in everyone's pockets, and listed the income limits just in case you're curious if you qualify. This is what I briefly mentioned about how you can certify that you qualify if your age is 18 to 24. Make sure you check that box. This is exactly what it looks like on the tax return. So just don't miss it, because if you don't check the box, you won't get the credit, and then you'll have to go through a whole process. Also on this slide is the prior year 2019 earned income. That's where you can put that if you want to use that number. The child tax credit has also been expanded. So first off, if you received advanced child tax credit payments, make sure you reconcile it on your tax return so that you're not claiming the entire child tax credit. You're claiming the amounts that you have not received yet. This year, no income requirement. You don't need earned income, and listed is the amounts: $3,600 for qualifying children under age 6 and $3,000 for 1 6 and older. The income limits are higher, so it's easier to get this credit. But the main item, and where I see most people mess up, is you need a qualifying child. The basic tests are relationship, residency, and age. Relationship, some people are surprised to find out that it doesn't just have to be a son or daughter. It could be a brother, it could be a sister, it can even be a niece or nephew. They list it better in the 1040 instructions, but there's a lot of different ways that the relationship test can be met. Residency, child has to live with you over half the year. Now there's another twist. The twist is it could be an alternating year of claiming a child situation by court order. So in that case, it doesn't have to be over half the year, but that's something that you would probably know from whether it was a divorce or just a parental acknowledgement situation. But there'd be a court document saying mother has even years to claim, father has odd years. Then the residency test does not need to be met. Under the age of 17, and child must have a social security number, some other requirements, and having a qualifying child is also the test for the earned income credit to claim that with children, but that one doesn't alternate. The education credit might be relevant to the audience today. There are 2 of them, the American Opportunity Credit and the Lifetime Learning Credit. So the basic requirements are listed, at least part-time student, and that is shown on the 1098T. A box would be checked. I believe the exact language is greater than half-time student, check. So your educational institutions should send you a 1098-T that'll list that. The other requirements, taking courses toward a degree, not convicted of felony drug offense, and then you need qualified education expenses that exceed any scholarship you receive. That same 1098-T form will list tuition and other fees, and then also your scholarships. But you can also claim other expenses such as books. I've seen someone claim a lab coat, goggles, but for that, you'll want to save the syllabus for that class, save the receipts, just in case the IRS wants you to prove those expenses. The state might also ask for that. So keep the receipts, keep your syllabus just in case. I know it might be a pain because you get a lot of syllabus, syllabi, I guess is the plural, but it'll save you some trouble if the IRS or the state asks about this credit. The other credit is a lifetime learning credit, a little bit broader. Grad students can claim it, but it's not refundable, so it's not as powerful of a credit to claim. To compare the credits, if you want to see which one is ideal, I put the link on the slide. That'll give you a good overview of both of them. Child independent care credit was also expanded by the IRS. It used to be $4,000 and $8,000, but now $8,000 and $16,000. You need earned income, but as I noted on the slide, students have earned income of $250 a month just by being a student. The IRS lets students list that. The exact wording that I found in the IRS instructions and on the IRS website is, it must be a work-related expense, care necessary because you worked or were seeking out work. I dug a little deeper, and students do qualify. Full-time students qualify. It was in another Internal Revenue Service manual, and they specifically did list that full-time students qualify. I don't know why they didn't put in the instructions, but you should feel comfortable taking this credit if you're a full-time student. Keep your receipts, childcare, daycare, summer day camps count, babysitters, things like that, and then claim it on your tax return. The homestead credit is a state credit. I just want to, it may sound simple or obvious to some people, but the Wisconsin Department of Revenue is not the Internal Revenue Service. Some people don't know the difference. So this is a state credit, and the income must be less than what's listed. Documentation for that, it's pretty straightforward. A rent certificate or the property tax bill that you paid. One problem I've heard of and seen people encounter is sometimes the landlord does not want to fill out the rent certificate. That's unfortunate, but there are instructions on the rent certificate what you do if that happens. It does require submitting receipts, so hopefully you have your rent receipts, and then you can verify how much you paid that way. But it's a good credit to claim. The state tries to get money in your pockets just as much as the IRS does. Now, of course, you don't want to spend money claiming these credits. So there is free tax return preparation. Like I said before, if you need to claim your stimulus money, if you need to claim taxes withheld, but aren't at the filing requirement, look up these free tax return preparation places. They'll help you sort out what credits you qualify for, what credits you should claim. They're VITA sites. I'm guessing most audience qualify for VITA more than TCE, but there are tax counseling for the elderly programs. And VITA, you can find if there's one near you by the link in the 4th bullet point. So most taxpayers qualified. I think the IRS has put out a study where VITA programs had the lowest amount of mistakes out of all the categories of tax return preparation. So that they're, even though they're volunteers, they're reliable. Don't quote me on that because it might be an outdated stat, but I remember hearing it. It's a place that you should feel comfortable going to and easy to locate on their website. And this is a handout that hopefully is distributed or will be distributed. It's just a tax preparation checklist from the Taxpayer Advocate Service. They are an independent branch of the IRS. They really seek to help taxpayers. And these 5 categories, they go into more detail for each one and will help you prepare to file your taxes, help you to assemble everything you need, and give you a little more understanding about what credits you may be able to claim. So now I'll turn it over to Jay.
Thank you. Thank you, Andrew, and thank you, Lawyers for Learners, for hosting this event. What I'd like to do is give a brief overview of the clinics, the eligibility for utilizing those clinics, and the services we provide. First of all, as Katie, I think, mentioned at the outset, there are 2 clinics that provide our services. One is Judicare, where Andrew is the director, and the other is Legal Action of Wisconsin, where, as mentioned, I'm a volunteer tax attorney. Broadly speaking, these clinics provide assistance to low-income taxpayers who have a dispute with the IRS. It's important to know that even though the clinics receive funding from the IRS to support these services, we're completely independent of them, meaning that we act as advocates for our clients in the same fashion that private law firms or accounting firms would do so for their clients. So we are pure advocates for the clients that we have. And with reference to the low income aspect of the clinics, it's not just left up to the individual as to whether they might qualify as low income. There's actual eligibility guidelines for that, which I believe will be or have been distributed to you. And it's based on a multiple of the federal poverty line, but the specific numbers are listed in the guidelines. So, for example, if you're a single person, you cannot, based on the guidelines, have more than $32,000 or so of income. If you have 4 people in the family, then it goes up commensurately. But something else I should add right here. If you or people you know who wish to take advantage of our services are at the upper end of the income eligibility guidelines or over it, but not by much. That should not deter you from calling our offices, because there is some wiggle room there, and we do have some discretion as to whether you might otherwise take advantage of what we have to provide. So again, I would encourage a phone call to make that determination and not just be deterred by the guidelines themselves. It is also important to note that we provide services in civil cases, meaning any type of tax dispute that does not involve a crime. So if there's somebody who has has a criminal tax fraud issue, that's not something we take. It's just something, it's simply involving a civil tax issue or a dispute as to the amount that's owing, what have you, in that regard. Also, we do not, and Andrew, of course, provided you resources that are available for doing tax preparation. We do not fill out or do returns for the current year for taxpayers. But if they have a dispute for prior years, which is going to be the case necessarily, and part of that dispute is the returns themselves, we will, in appropriate circumstances, help prepare the returns there. And finally, it's you should note that if the only issue is one of state income taxes, we are not supposed to step in there either. However, if you have a federal and state issue, we will assist with both. And quite often, not always, but quite often, the state piggybacks onto what the IRS does. Finally, just the final bullet on that page indicates that we provide services in the complete range of administrative processes that occur with tax disputes, and that's listed there. Audits, appeals, that's within the IRS. If you get some sort of an adjustment, you can take it up to the next level of the IRS, and then even beyond that, when we get into collection disputes, which we'll talk about a bit later, there again, we will stand by you in those cases, or your clients. And this includes not only in front of the IRS, but tax court, if the matter gets to that level, and that even district court, federal district court, although that's very rare. I actually had one case that was in federal district court, but I expect I'll never have another one. And even in tax court, these cases usually get resolved without a full-blown trial, but it's something worth noting. Let's go on to the next page. And even before I get to collections, I should mention one thing. So we've cleared the eligibility requirements. So the first thing I ask after that, and there's a, if you will, a fork in the road. The fork is, or the questions to ask at the outset is, do you owe the tax? And second, if you do owe the tax, of course, you get into how are we going to resolve this? But in some cases, we have taxpayers who don't think they owe the tax to begin with. And we don't have a slide on this, so this is kind of between slide one and this slide. But bear that in mind. So let me give you an example of where that could come into play, and it might be quite pertinent here. Say you are a student that has student debt, and it's the type where you don't have any special status, but you're in a position where you can't pay it, and eventually the lender is going to write it off as uncollectible. The general tax rule in that situation is that it's includable in income when the lender writes it off or discharges it or forgives it, whatever term you want to use. And that is, we do see cases like that on a fairly regular basis. But if you're in that situation, there's also exceptions under the law. One of the exceptions is if you are insolvent at the time that the debt is forgiven, meaning you have liabilities in excess of assets, then the the debt is excluded from income and you don't owe the tax. So it's not a matter of negotiating as to what you can pay or not pay. You just don't owe it flat out. And again, that's something that we see on a fairly regular basis. But I will acknowledge, and now I'm getting to the matter of collections, that in most of the cases, we have taxpayers who do owe the tax. That could be they never filed a return where they owed taxes. They did file a return, but they didn't pay the tax that they showed that they earned, or on an examination of a return or an individual's tax situation, the IRS determines and the taxpayer agrees that they do owe the tax. So what are the options in that case? Well, as the slide here shows, there are three, generally speaking. There's an installment agreement, something called currently not collectible, and finally an offer and compromise. And as the slide indicates, we will help with all of those, but let's take a closer look at each of them. So if we could go on to the next slide. Installment agreements are pretty much as you might expect from the wording. You can't pay the tax up front, but you can pay the full amount of the tax if it's spread out over a period of time, whether it be several months or even into several years. There are different types of installment agreements as noted here, but basically, again, they cover situations where if given time, you can pay it. And this is something to consider in those types of situations. Rather than ignoring the situation altogether, it's important to note, because even though there is some very modest interest that applies to the payments that have to be made under the terms, it's still dramatically less than what you would have to pay the IRS if the amount owed simply accrues and interest builds up on it. So again, an option to consider. But at least in my case, and Andrew can speak for himself, in my case, I've only had a few installment agreements. We usually look at the final two type of arrangements where we offer assistance. So if we could go on to currently not collectible. Now, this is something that is quite common. And it applies in a situation where the taxpayer is simply financially unable to pay the IRS without causing an undue hardship, as the wording explains there. But again, the situation is more precise than those words would suggest. You have to fill out, or we fill out on your behalf, a collection information statement that totes up your income and expenses and also assets. And if your expenses exceed your income, then you are a very viable candidate to qualify under this provision. And let me tell you briefly before I add to this what this entails. If the IRS agrees that you qualify for hardship or CNC status, what it means is they're not going to take any action to try to collect the tax from you as long as you qualify for this status. If you have refunds coming to you, they can collect that, but they're not going to garnish your wages. They're not going to try to seize assets. And furthermore, if your situation doesn't change for 10 years after the date of a tax assessment, which is a technical term, but just go with me here. If you reach that 10-year period and your situation hasn't changed, you're still in hardship status, then the tax debt will be wiped off the books. But prior to that, it remains on the books and interest accrues. So you're not out of the woods, but it does give you breathing room and ultimately more than breathing room. But here's the problem that exists right now, and I think Andrew would agree with me on this, because you can do this, believe it or not, by phone call on a professional hotline or priority line, speaking to someone with the IRS on the phone and over the phone. You know, if you can get a hold of someone, you can reach a resolution determining that someone's does qualify. So it's remarkably efficient for dealing with the government. But the catch is, recently, it's very hard to get a hold of the IRS, and you get messages back saying, please try us at another time. And then when you try it another time, you still can't get a hold of them. Now, this doesn't always hold, and it's definitely worth trying, but it's been a source of frustration for tax practitioners. And hopefully that is because of a shortage of staff, it's because of the virus, it's because of a host of circumstances. And I'm sure the IRS is aware of it, and hopefully that'll clear up. But again, it is a very attractive option for people who qualify. And this is a cash flow situation. So taxpayers simply do not have the money to pay this under the circumstances that exist for them. So let's go on to the next slide. Beyond that, and the final option is something called an offer in compromise, where again, as the terms would suggest, you reach an agreement with the IRS to pay some amount less than what you owe. Now, if this situation prevails, I believe this is the best of all results, because if you reach an agreement with the IRS in this matter, you don't have this 10-year period hanging over you like you do with the hardship or CNC status. This resolves the issue for once and for all. I shouldn't mention, yes, there are conditions going forward you have to meet, like paying your taxes you owe for future returns. But other than that, it is something that has finality to it. And so it's something that we look to achieve with the clients that we have. Let me mention at the outset, as far as this option is concerned, that it focuses not only on your income and expenses, but also on your assets. So before we go on to the next slide, let me clarify there. So if you have, maybe your income relative to your expenses are underwater, so to speak. But if you have assets, for example, a car that's not subject to a car loan, bank accounts, stocks, although that's not usually the situation we find people in, but if those exist, and if you own a home in which you have equity in the home, the IRS looks at that too. So there are additional hurdles to cover if you're going to pursue the offer in compromise route. Let's go on to the next page. Okay, so there are different options for pursuing a compromise. The one I almost always use is what's called a lump sum offer. Because again, you're trying to reach a settlement with the IRS where the taxpayer is paying something that's manageable for him or her. And it's going to be, we hope, quite a bit less than what the original amount that the IRS has determined. And if it gets down to a very manageable result, my hope is that then they can pay it off in a relatively short period of time, which is the lump sum offer, meaning that, and even that's a misnomer, because you can pay it in 5 installments, not necessarily in a lump sum, and over 5 months or less. Even that's in the form itself that has to be filled out. So that's where I've done almost all of my offers. And again, Andrew may very well have different circumstances. And an important thing to add, which shows up on a further slide, is you'll see below the lump sum offers, accompanied by a payment of 20%. Okay, that's true as a general rule, but here's an important thing to know. For low income taxpayers, and the income eligibility is pretty darn close to what the income eligibility is for using our services. There is a waiver of having to make an upfront payment, and there's also a waiver of the filing fees, which is normally $183. So that's a substantial amount for some folks. And so almost all of our clients fit within this waiver, meaning you don't have to make any payment until and unless the IRS accepts the offer, and then you need to make it within this 5-month period. Okay, let's go on to the next slide, please. So there are, technically speaking, 4 different ways of achieving offer. I'm not going to spend any time really on doubt as to liability, because let's face it, if there's a doubt as to liability, hopefully you would have resolved the issue as to what the liability is before you ever got to this stage. At this stage, there's not much doubt about the liability. You know you owe it. It's a matter of what is the lesser amount you can negotiate with the IRS. And even as to the last 3 bullets, yes, there's doubt as to collectability, which we'll talk about in a second. But the last 2, doubt as to collection with special circumstances and effective tax administration, those basically merge into one. So let's take a look at doubt as to, let's skip over doubt as to liability. I think I've already covered that. A doubt as to collectability, again, that's a situation that does come up on a fairly common or a frequent situation. And again, unlike the hardship status, if you achieve something under this provision, you're able to get the finality to the issue, and this is something I'm sure you understand this. A lot of people who aren't familiar with dealing with the IRS hate having this cloud over their heads. They don't like the IRS lurking in the background. So to be able to remove that cloud, if you will, is very important to taxpayers. And this provides an option for that. And again, as you'll see at the bottom of the page, these charges can be waived and are normally waived for low-income taxpayers. Finally, let's go on. But let's say that because of, still on this page, excuse me. Again, this is just emphasizing what I said earlier. Besides looking at income and expenses, the IRS really zeroes in on assets. So in most cases, we do not have clients who own a home, but I've certainly had cases where they do, and I suspect Andrew has as well. And that gets a little stickier because it is fair game to look at the equity in a house and say, hey, can't you access that? This is the IRS speaking, to pay off what you owe, or at least more than what you are claiming you should have to pay in compromise of the issue. So there is back and forth on that. And based on doubt as to collectability, you may be in a very tight spot as far as convincing the IRS. But fortunately, that's not the only avenue you can pursue. So if we'll go on to the next page, please. Special circumstances or exceptional circumstances or effective tax administration, what have you. This is where, if I can use the term again, wiggle room comes into play. There are not as many hard and fast rules. So let's say you do own a home, and you do have equity in your home. You can argue here a variety of things. One is for the bank is not going to lend you money based on the equity in the home, and you submit a statement from the bank saying they will not. Well, the IRS pays attention to that. Or let's say if this was to be foreclosed upon or the equity taken away, you would have an extremely difficult time finding another place to live. IRS pays attention to that. IRS pays attention to the age. IRS pays attention if you have health issues. I have a client right now who has multiple sclerosis. but there's a home ownership issue involved. Well, that presents, again, a special type of circumstance. It's very important to note that for all of these things, and I haven't emphasized this, the IRS isn't going to simply take your word for it. You need to provide documentation, and in some instances, lots of documentation. But this is an area where, again, we're more than willing to help and do help. So let's move on to the next page, if I may. Again, as I said earlier, this kind of merges with the special circumstances. There's probably a technical distinction, but as a practical matter, I don't really get it. So here again, look at the second bullet, for example, equitable considerations. So anything that is sympathetic to the taxpayer, you argue here. The important thing is don't give up if the IRS is providing an obstacle or resistance to doubt as to collectability. Under special circumstances and effective tax administration, you're able to wheel and deal and be more creative in the things that you want to advocate. Doesn't mean you're always going to prevail. I don't mean to say that, but it means that you should not give up, or we should not give up on your behalf if a situation like this occurs. So next page, please. In any event, this is to reiterate what was said at the beginning. Either you think you qualify or you may qualify for our services and feel like you need them. You should definitely reach out to us. And again, you have Judicare's number and legal actions number in emails. And I like the bold print at the bottom. We both serve taxpayers statewide. Andrew and his shop and we at ours serve the entire state. There used to be more tax clinics doing this job in Wisconsin, but there's 2 now. And we are ready and willing to help you with tax issues as they arise within the parameters laid out. So that's the last thing I want to say on that. I guess we turn it over to Katie as far as any questions that may have arisen.
Hi, yes, there was a question that was raised during Andrew's portion of the presentation. So this question's for you, Andrew, and it says, if I do not claim my child on my 2021 taxes because of alternating year claiming as in my divorce document, then I cannot claim the child tax credit because it is not my year to claim my child?
Yes, that's right. She cannot claim the child tax credit, but she probably can claim the earned income credit because that you cannot relinquish, and that does go by the residency requirement.
Great, thank you. Is there any other questions from folks that are on the presentation? Question from Jill, can we give out that contact information to our students? What contact info should we use?
Is that to both of us?
Yep.
I would think, I mean, we gave out the numbers and the email addresses, and I would think it absolutely could be made available to the students. Andrew, do you have anything to add on that?
I think the best thing to do is call the number and then apply, because it's really difficult to know what level of service we can provide if you don't go through the normal channel.
And then another, oh, go ahead, Jay.
It was just, maybe I'm being repetitive, but yeah, to underscore what Andrew said, when people call in, there's someone that goes through some preliminary questions to see whether this person qualifies for our services. So that's usually done at the outset.
And then there's another question in the chat as well. And the question is, how can credits be claimed when filing jointly with a spouse?
Did you want to take that, Jay, or?
No, I thought that would be in your bailiwick.
Okay. Well, the exact same way. There's different income limits for when you have a spouse there. As long as you're filing jointly, you can try and claim all of those credits, but there's different income limits. There's different amounts, things like that. And it's just a matter of going through the process of looking at the credit, finding out, listing the amounts, such as the earned income credit, finding the married filing jointly part, and if you have kids, then locating that credit amount. So it's pretty much the same process. You just have to look at different columns or a different rule section.
But the important point, right, Andrew, is that merely the fact that you're married and filing jointly is not a deterrence.
Not at all. Sometimes it's actually a benefit.
We cannot thank you guys enough for sharing your expertise with us and doing all of that. I would want to say, if anyone has any tax questions or things that might be, feel free to fill out a Lawyers for Learners intake form so we can get you to that's another resource to get you to the place that you guys need to go. But thank you all so much. We are recording this and we'll be sending this on. So if you find this helpful, that you can forward it to someone else that wasn't able to be here today. But thank you, Jay. Thank you, Andrew. You're incredible. And we so appreciate everyone's time.
Thank you.
Thank you as well.
Have a wonderful day, everyone.